All right. So I'm going to kick us off here. Thanks everyone for joining us. I'm Mark Hefner with Plateau Land and Wildlife and Braun Gresham. I'm the landowner advisor. And my role as a landowner advisor is to understand the unique issues that Texas landowners come into contact with and help them potentially resolve it, introduce them to experts that can help, and basically understand what their needs are. Braun Gresham is a law firm that has a great amount of experience in facing those unique issues, such as real estate transactions, eminent domain cases, and conservation strategies for legacy land. The sister company, Plateau Land and Wildlife Management, helps folks with wildlife management filings, as well as ag expertise. And we also have a team of expert biologists. Today, I'd like to introduce Carly Barton and Patrick Reznik. They are both attorneys and counselors, and we've been working together for quite a while, again, helping landowners resolve issues and be their voice. And so Carly and Patrick today are going to be helping us out. We're going to use more of a real-time question and answer situation where you can unmute yourself. We will allow that. You will have to unmute yourself on your screen. If you hover over your screen, usually at the bottom left, you'll see a little microphone. You can unclick that. It has a red line through it now. Feel free to jump in at any point and ask a question. If you have something that's confidential or would prefer not to ask in front of the audience, feel free to use the Q&A segment or the Q&A portion. You can type it in and I'll be monitoring those and can help, again, interject those questions for you. You'll also receive all of our contact information at the end of the meeting. Feel free to email us, call us, however, maybe whatever feels more comfortable for you. The last thing I want to say is we're going to have this meeting recorded. So I'll go back to my earlier statement. If you have something confidential or prefer to take this offline, please feel comfortable doing that. You'll have enough information to get a hold of us, but we will be recording. And without further ado, I'm going to introduce Patrick and Carly and let them take it. Thank you, guys.
Good afternoon, everyone. It's a pleasure to be a part of this presentation along with Carly. I'm a Texan. I grew up in Texas on farms and ranches and have worked all over the state of Texas and love what I do representing only landowners. We've had the opportunity to work with condemning authorities, and we've always rejected that because we like representing landowners and are advocates for their rights, and that's the side I've chosen, and I love it, and I'm going to stick with it. So, Carly, how about you?
Well, I didn't grow up on ranches, but I did grow up in Texas and in Austin area, and I'm glad to be back in Hays County. But I, like Patrick, enjoy representing landowners and the issues that they have and trying to resolve the disputes they have, whether through litigation or any other means. But we're here today because a big part of our practice is that we help landowners through the condemnation practice or the condemnation process. And so we're here today to talk about eminent domain, what it is, who can use it, and how can it affect landowners here in the state of Texas. So the title of our presentation is, "You mean a private company can take my land?" And the answer to that is yes, they can. And we're going to talk about the circumstances that can lead to that.
That's great, Carly. Thank you so much. And this is a complicated process. You may be wondering, why hire a lawyer? I think through the end of this process, that question should be answered. But if not, please ask it again and we'll give a better explanation. So, Carly, you're going to take the first of those bullets.
Yeah, so just an overview of what we're going to be covering today. First, we're going to talk about the power of eminent domain, and then what does just compensation and receiving compensation mean to landowners. A few examples and case studies of ways we've helped landowners receive that just compensation, and then the process, the condemnation process, and the steps that you have to go through that if you are being condemned. So to the first part, the power of eminent domain. So where does this power come from? Well, just like most of our laws and regulations in the United States, it comes from the Constitution. So first, we have the United States Constitution under the Fifth Amendment that requires a private company to compensate citizens when it takes private property for a public use. So a governmental entity can come in and take your land, but they can also allow a private company to do that as well, as long as they are using it for, it has this public use idea. Typically, how we see that is we can see that in transmission lines, in sewer lines, water lines. You can see it in roads, sometimes with toll roads. But certainly there is a kind of greater good aspect to the reason why a private company can take your land or take an easement if they're not taking all of the land. Another important thing is that a public use can be economic development. So it doesn't have to be necessarily kind of these infrastructure type of kind of projects. It can also be for economic development in terms of if there's a kind of a bad neighborhood and they want to raise the buildings and build, new apartments and new shops and things like that, that also can be for the public use. So that's the United States Constitution. In the Texas Constitution, there is also a similar grant of power for eminent domain. And that is in Article 1 of Section 17 that says no person's property shall be taken, damaged, or destroyed for or applied to public use without adequate compensation being made. And you'll see that a lot in our discussions here today about this adequate compensation or just compensation. Those are really important terms for landowners because that is what they are supposed to be getting from the government for this taking their land. And so we as advocates for landowners are obviously very focused on that part of the eminent domain and condemnation process. Eminent domain is the power. Condemnation is how the formal act of the government using eminent domain. So that's kind of the difference between those terms. So we'll be concerned with just compensation. We're concerned with the public use because we want to make sure that these private companies who are coming in and trying to take your land are doing it for the public and not just for their private purpose or their private gain. And then we have Chapter 21 of the Texas Property Code. Those are the regulations and steps that a condemning authority in Texas has to go through in order to condemn a property. Most of those are outlined. We'll go through them at the very end of this under the steps of the condemnation process. But that is a statute that helps protect landowners, or at least outlines what to be expected in the process. So who has the power of eminent domain? So we talked a little bit about this, but in terms of private companies, there can be many. We've got oil and gas pipelines, we've got electric transmission lines, water transmission lines. There's rail that can also be used. So those are the private companies that have eminent domain power because they are supposed to be using it for a public use. Of course, the federal government has eminent domain power. The state of Texas, a lot of times in the state of Texas, how we see them using their power is through TxDOT and building roads. We also, your local electric co-op, your special utility district, your municipal utility district, these kinds of local governmental entities that get, are created by the Texas legislature. They can also have eminent domain authority through statute and through the Texas Constitution. And then, of course, counties, cities, school districts, and even hospitals can have this power to take someone's land.
Hey,
I'm gonna
Carly,
throw it over to Patrick. Yes.
or Carly or Patrick, this is, I'm an average landowner here in Texas. And so if I understood that clearly, and maybe I'm being a little redundant, but it's my understanding with what you just said, if I own property, a private company can come in and actually condemn or take a piece of my land for some public works project or whatever it is. And so that's what I heard. Is that an understanding? Am I understanding that correctly?
Yes, that's absolutely true. As long as it's for a public use and they pay you just compensation, they can absolutely come. A private company can come take your land. And so Patrick's going to talk a little bit about what does that compensation look like? What does just compensation look like?
Thank you.
Mark. That's a good question. And thank you, Carly, for what you introduced as far as the reasons, various private companies as well as the government agencies can condemn. A lot of times, people ask, well, can they really do this? Do they have the authority? And that's called the right to take. And Carly's going to address that later on. I'm going to assume for the sake of this presentation on this segment that they have the right to actually condemn, and we're not going to challenge that. Most landowners ask me, well, if they have the power of eminent domain, they can condemn, they can take. And take is a very important word. That's the term that we use when they're taking something from us, and it's not voluntary. It's by eminent domain authority that they can do it. So they're taking it. If I can't prevent it, then the landowner is going to ask, well, how much am I going to get compensated? What am I going to get? So let's do the next slide and talk a little bit about how compensation is considered. Essentially, the big picture under the U.S. Courts and the state courts is that the landowner should receive compensation. It should be adequate compensation. What does that mean? Well, that means what is the value of my property before the taking and after the taking? That's essentially it. How much does this project impact what's been taken and the remainder of the portion? So the devaluation of the whole property. Considerations are if TxDOT or a county or city is taking my land for a new road, they're actually going to own that in fee, not as an easement. If a pipeline company is going to, or transmission line company is going to be taking my land, they're going to be taking that land for an easement. So the landowner still owns the land, but an easement is the right for one of these companies to build the infrastructure, to operate the infrastructure, to maintain and repair the infrastructure. And yes, the landowner still gets to pay the taxes on the whole property, and the appraisal districts are not going to reduce the value of your property because of these easements. And many people ask, well, that's not fair. No, it's not fair, but that's what appraisal districts do. We as landowners look at the big picture to go, okay, what is the value of this taking? What is the value of this easement? What is the impacts to the overall property? Besides taking land, are there buildings that are impacted? Are they going to limit the availability to access portions of the property? Are there compensation, not just for the permanent easement, but are there temporary easements? What's the construction? What's the impact of the property during construction? If I run cattle or I have horses or other animals, are they going to be impacted? Are they potentially going to be in danger because of the construction? All of this are things that need to be considered. I always tell my clients, make a wish list, think of everything that you can think of that could be impacted, and we'll work through that to see if the law gives compensation for that, or sometimes the companies are a lot more workable as far as even going beyond the law to try to take care of the landowners. That's becoming less and less as things have changed. Many of these condemning authorities don't consider themselves, especially with an easement, that they're partnering with the landowner. Those days seem to be gone, and it's becoming a little bit, quite frankly, a little bit more hostile with respect to what they're offering and the kind of strategies that we have to use in order to get fair compensation. Next slide, Carly, is this picture is just a simple idea of the red is the part taken and what's the remainder. So we value the value, what is the part that's actually taken, whether it's in fee, they own it, or again, as an easement. And then what's the impact to the remainder? For example, A transmission line is going to be above ground. If the red is the easement, that is now going to be a visual impact to the rest of the property. So if you have a house, a home that you live in, whether it's a barndominium, whether it's $1 million home, or whether it's a manufactured home, how's the value of that impact? Because now you look to the west, look at the sunset, and now you have this big transmission line in your way, as compared to a petroleum line or a gas line. With a gas line, there's many concerns about leaks, about explosions, what are the impacts of that? Those perceptions, whether an explosion ever happens or not, people who buy properties, if they know there's a gas line there, often have concerns. That can devalue the whole property. So we look at the remainder damages. Sometimes there's very little, and sometimes they could be up to 45% on the whole value of the property. It all depends on the property, what the property is being used for, the infrastructure on the property. Is it used for recreational? Is it used for agriculture? Or is it used for future development because it's in an area that the highest and best use from an appraisal standpoint is going to be for residential development or commercial development. That's happening in lots of parts of the state of Texas as our communities are growing, population is growing. Again, the thing to consider is, what is the total compensation that I'm entitled to? What's the total value before and what's the total value after? What is that difference? You'll see here in a few minutes some examples of how those numbers can vastly differ between what our opinions are, what a condemning authority's opinion is, and what we believe is fair, and some of the results that we've obtained. Thanks, Carly.
Yeah, let's go into those, because those are I think the most interesting part of this presentation, because you can see the real world implication of the power of eminent domain and what it means for a landowner and what we can do in terms of representing them. So this first one we have is a LCRA transmission line. That is a big electric transmission line that's running through someone's piece of land. The initial offer for, which is the initial offer is what the LCRA has given to the landowner. In this case, because they wanted to entice the landowner to take that first offer, they had a 35% increase of a signing bonus. Then there was the appraisal that LCRA had to provide to the landowner. And their appraisal put it at about $500,000. And then we had our own appraiser who came out and did his own assessment of what was just compensation. So what was the damages to the part taken and the remainder, just like Patrick was talking about. And in that case was resolved, and it ended up being $920,000 to the landowner in terms of what the damages were, or what did the just compensation mean.
And Carly, if I can just emphasize that the resolution is, close to 3 times about what that initial offer was, because they gave that bonus. What that is designed to do is, from an emotional impact of the landowner, they're like, oh my gosh, they're only going to give 366, but they're being kind and generous and offering this bonus. That's designed to entice you to go ahead and take the 494. And then because this landowner waited, they got the 508, but because we hired an appraiser and we did this, we were able to get the full number up. And so, the resolution, as you can see, 920 is quite significantly different than the initial offer or the final offer, which was the appraised offer from LCRA, which is a quasi-governmental agency. And we'll talk more about the initial offers and final offers later, but Carly, continue. But these 3 give kind of strategies that various companies use in order to try to get the what we call ink on the paper to get these things settled quickly.
Yeah, so the next one is it's the Vista Ridge water line that is going down to San Antonio, and their initial offer was $95,510, and then their appraisal that they had was that exact amount. And when Patrick's talking about strategies, this is one. They're saying, hey, this is our offer. Now look at how reasonable our offer is, because here's an appraisal that says that it's spot on. So that was their strategy. Of course, we went out, did our own appraisal, and that came out to $493,200. Almost $400,000 more than what they had appraised it as. And that is ultimately the resolution that we were able to get for the client. So you can see that there can be quite a large discrepancy between what these condemning authorities offer versus what the landowner can get under the just compensation. And then the last one we have here is an enterprise pipeline. Their initial offer was $168,101. And they took the reverse approach of saying, hey, we're going to give you a really great initial offer, and we're going to give you an appraisal. The appraisal is going to be way, way lower, to show you how great and reasonable our first offer was. And that the appraisal final offer was $26,356. Again, our appraiser appraised the property at $746,394, and that case ultimately resolved at $515,000. So you can see in this, like Patrick said, there's different strategies that condemning authorities use. All of these entities are kind of either a quasi-governmental agency or entity or a private company in terms of enterprise, but all are using the power of eminent domain for these takings to landowners.
Thanks, Carly. A couple of things. The Vista Ridge water line. Vista Ridge is a private water corporation that was created, but the idea behind this one was eventually to give this to San Antonio Water Systems. Carly mentioned it's a water line that's coming from East Texas, building a 60-inch, 5-foot diameter water line to bring a ton of water into the San Antonio area. So it's a private company that is doing this for a public purpose, but eventually it will go to a quasi-governmental agency that will operate it. And the enterprise pipeline, it's interesting on this particular project, this was their third pipeline. So this was paralleling two existing lines. It's a petroleum line, not a gas line, which has a different type of impact than a gas line. But the reason this appraisal is $746,000, it's pretty high. And one thing that we as landowner attorneys often try to do is work to improve landowner rights. This is what's called a corridor authority. Our idea was like, listen, the highest and best use is for another pipeline. So you shouldn't be paying just land values. You should be paying more because the landowner now has a third pipeline. So you ought to pay more because you're thirty this pipeline in. There is some case law that has helped in us to support this theory, but it was a very interesting case. Thanks, Carly.
Yeah. And if anyone has any questions at any point, please type them in, unmute yourself. We love answering them and talking back and forth. So feel free to ask away.
And one more thing, I want everybody to kind of get the feeling, if you're a landowner and there's three different strategies here by these three different companies, it's a very an emotional reaction when a landowner is first told that their property is going to be condemned. And then you get this initial offer in the enterprise case of 168. And they say, but if you take us to the full condemnation process, we're only going to give you 26. Imagine the feeling of a landowner going, oh my gosh, I'm losing control. I have no control. I better hurry up and take the 168, because if not, and they take me through the full condemnation process, I'm only going to get $26,000. I often talk with landowners about you're in the initial stages of grief. If you're angry, you have an absolute right to be angry, because your land is being taken by force. If they have the power to condemn, getting to the point of acceptance and figuring out, what is the best resolution for the landowner is where we have to eventually get. Thanks, Carly.
Hey, just a heads up, Carly and Patrick, we've got, it's 12:31. So just letting you know as far as your timing goes.
All right. Thanks, Mark. So now we're going to get into those formal steps of the condemnation process and what that means for landowners in Texas, and how does this whole power of eminent domain play out in the real world. So the first step that we have is phase 1 is, and I can't read my screen because stuff are falling in, survey and route plan. So this is when the condemning authority, the friendly landman comes out and requests a survey. And we say that the friendly landman because typically they're going to get someone who is going to be pretty nice and is there just saying, oh, we just want to check things out. And they're not going to really scare you too much at this point because they want your cooperation. And as it says on the slide, your cooperation is beneficial because you can get a good idea. You can ask them questions. You can figure out what the project's about. What are they taking? And many times you can negotiate terms of that access to make sure that they're not just coming in on your property whenever they want. Because as it says, refusal results in a court injunction. So that means under the Texas property code, a condemning authority has the right to come in and survey on your property. If they have the right to condemn, they have the right to come in and survey. And if you stand at your gate with a shotgun and won't let the friendly landman on your property, you'll find yourself in court because they'll get an injunction against you so that they can have access to the property. So that's why that cooperation at this point is beneficial, so that you can know what's going on and what are the plans, and try and pump them for as much as information as they have. And it can start the dialogue in terms of the route and if there's any considerations on your land that and if it's possible to change the route at all.
And Carly, what we do as the landowner attorneys is we work up a right of entry agreement, which gives a time frame, which limits the access to the property, which limits also the survey techniques. So it's not destructive. It limits, any taking down of trees on the survey or anything of that nature. We also like to make sure that there's liability protection. So anybody on the landowner's property is responsible for any particular damages or if somebody's hurt as a result. So as landowner attorneys, we provide that service. We still have to give them the right to survey, but it can be a right of entry agreement that gives very specific details and notice requirements so that when they're going to be there. Thanks, Carly.
Absolutely. So the second phase we have is the offer and negotiation. So we talked a little bit on the during our case studies, you had that initial offer. So that initial offer, it has to be written. It has to be in a letter and given to you by typically a landman or a right-of-way agent. And so as we saw in those case studies as well, that offer is typically low, or they like to point out that they're giving you a signing bonus that if you accept that offer. But this offer in the terms of the easement and it's a contract. That's all it is. So they are negotiable, and there are many different kinds of considerations, that the landowner can take into account. So it's not just about, you have compensation for the taking, you have remainder issues, and I'm going to let Patrick talk about those in terms of what are some good considerations for you to take into account.
As we talked about earlier, it's the value of what's being taken, whether it's in fee or an easement. what's the damages to the remaining portion of the property. Depending on the property too, there's non-compensable items that can be considered, such as, am I going to need some variances from the city or from the county? What's the impacts on water? What's the impacts on wastewater? Are there utility lines that are going to have to be moved? A lot of times the impervious cover is going to be taken, so that's going to be reduced. Can I go to the city and get a waiver so that my impervious cover, while if it was a new construction, would be not enough, but I can get a variance from that. So there's lots of things just from a land use standpoint that are non-compensable items can actually enhance the value of the property if you know what to ask for and you know who to go talk to and negotiate with. And also, you may have a building that's taken out. And if you have a building that's taken out, when we've had lots of these situations where only a portion of the building is taken out, or if it's a infrastructure that it's going to be so close to an existing building, the net result is you can't use the building. So you should be paid for the value of that building.
Yeah. So, and like we discussed, there's the written initial offer, but these offers have to be what they call bona fide offers, right? They have to be justified in terms of an appraisal or of real estate value. They cannot be, has to be what they call an arm's length transaction. It can't be you're selling a couple acres to your best friend and neighbor that you've known forever, and so you're going to give them a discount. So they need to be bona fide offers. You'll get the initial offer from the condemnor. It'll include the easement. It will include things like the landowner's bill of rights, which is something that the state of Texas puts out to kind of inform landowners of some of the things that they need to be considering when their property is getting condemned. So there's usually the condemning authorities usually put a 30-day deadline on their offers. Honestly, most of the times these deadlines aren't real, for lack of a better word. They're just to pressure landowners. But the law requires that there must be a written appraisal, and there's a 14-day deadline final offer before you can have what's called a special commissioner's hearing, which we'll go into that. But this time, when you're getting these initial offers and final offers, and you're getting the appraisals, and there's all these terms that you don't understand, it is an incredibly critical time to consult with an attorney, figure out, is it one of those situations where they're giving you such a lowball first offer that there is that you need to keep fighting with them and keep moving forward in the condemnation process to get your just compensation, and also to consider to go into all those considerations that Patrick talked about, and that with land use and taking of a building, and all those things can happen. And so during this initial and final offer stage is typically when things are starting to really get interesting, and landowners need to start making some decisions, and attorneys can help with that.
And Carly, the 30-day deadline and 14-day deadline, those are statutory under Chapter 21 of the Texas Property Code that Carly mentioned at the very beginning. Those are not random. Those are required by statute in order to comply with a bona fide offer under Chapter 21. So they're very short. This could mean that the condemnation process after the 14-day final offer has expired could move very, very quickly, or it could take months, and sometimes, quite frankly, sometimes year in certain cases.
So what happens after these initial and final offers is we get to phase 3, which is a lawsuit gets filed. I think probably one of the most common things I hear from our clients who are getting condemned is that they didn't realize they were going to get sued. So you are being sued. they'll file, the condemning authority will file what's called a petition in condemnation. And that will be filed either in the county court at law or probate court in the county that the property is in, or it's in the district court in the county, in the district court level of where the property is. So it is a lawsuit. And then once that lawsuit, in the petition, it will have, who is the condemning authority. It'll have the reasons why, it'll cite the legal reasons why they believe they have the right to take and they have the right to eminent domain. Then they also have more information about exactly what they are taking it for. So if it's for a pipeline, it'll have information of, if the oil and gas and other petrocarbons, or how wide it is, is it multiple pipelines or is it just one? The petition will have some of those terms that would be typically in the easement between them. And so after that petition is filed and after you've got this final offer, you also have what's called the special commissioners hearing. And the special commissioners, they're not your county commissioners, they're different, but they are appointed by the judge where the petition is filed, in the court that the petition is filed in. And your special commissioners are 3 disinterested resident landowners. So they have to be in that county where your land is. So they should be your neighbors. They have to live there. They can't just own the property. And, typically the judges have a list of people that they have used in the past. A lot of times you get real estate agents, appraisers, people in the community. You get this kind of professionals that are familiar with, or at least vaguely familiar with real estate in the area. And so they will be your judges, for lack of a better word, and they will decide what they think that the just compensation is. So at it, the condemning authority, they'll bring their appraiser, they'll put him on the stand and ask him questions about his appraisal. And then the landowner's attorney or just the landowner can ask that appraiser questions as well and figure out where they came up with that methodology and if there are any ways to attack his or her methodology. That's the condemning authority's expert. Then the landowner can also can testify, get called to the stand and talk to the 3 special commissioners, and also have their own experts testify as well. So your appraiser, your land planner, an engineer, anyone who's going to be able to talk about the impacts of this project on your piece of property will be able to present testimony to the special commissioners so that they understand what's going on. Now, I don't want y'all to get too scared. It's not some big scary courtroom or anything like that. It's a very informal hearing. It's usually in a hotel conference room, and there's no rules of evidence or procedure. There's not going to be there's not objections. It's not Law and Order. So, but it's a way for both sides to present their information to a neutral decision maker to try and figure out what that just compensation might be. And as it says at the bottom, that they only decide the compensation, the amount of money that the landowner would get. They do not decide any issues about if they actually had the power of eminent domain, and if they actually, if they had the power of eminent domain, or if they had the right to take, or if it's a public use. That would come at a challenge later on in the lawsuit part in the district court. So the important step of the special commissioners hearing is that whatever the special commissioners decide for just compensation, that is the amount of money that the condemning authority puts up in the registry of the court in order to have the right to start their project. So the right to possession of the either piece of the taking of the piece of land that they would like, and the right to start construction. So it is an important procedural step. It doesn't have to be the end. Sometimes it is, but sometimes it's not. But it's an important step because after the special commissioner's hearing happens and they pick an amount of money for the compensation, if the condemning authority wants to start their project, they've got to put that money in the registry of the court, and the landowner can take that money out in certain circumstances. You have anything to add, Patrick?
No, you covered it very, very well. I will add that if it's a taking for an easement, the petition controls the easement terms unless you negotiate an easement outside of the petition, which can be very, very important. Most of the times the petitions are very bare bones and don't include a lot of the things that we like to provide for landowners protections. The commissioners, the special commissioners, don't decide easement terms. So there's some struggle between the condemning authority saying, we'll negotiate an easement, but only if you agree to compensation. Depending on the project, depending on the land, sometimes the easement terms can be more valuable than just the compensation. But it's something that has to be adjusted. I consider it two buckets that you're dealing with. But again, the commissioners, the laws do not have specific items for easements. And that's crazy, but we're working with the Texas legislature to try to change that. So there's some basic landowner rights with respect to easement terms that they have to put in there. But as of today, it's completely within the discretion of the condemning authority.
And so now we get to the last phase, is the appeal to the trial court. So if you don't get the amount of money you want at the special commissioner's hearing, or if the condemning authority doesn't get the amount of money that they want at the special commissioner's hearing, you appeal your case to the trial court. So that's that county court at law, the probate court, or the district court, wherever that petition is filed. And so you get to take it and you get to appeal it, and then it just becomes like a regular lawsuit. There's discovery, there's pretrial hearings, and then there is potentially a jury trial if you take it that far. And the jury trial, and the jury will decide what they believe is just compensation. And so you'll have, this can be an expensive process because you need experts, right? You need that appraiser, you need that land planner, sometimes the engineer, you need them to be there to testify to the impacts of your land and and what that means financially, to the value of your land. So so an appeal to the trial court can be expensive if you take it all the way to a jury trial. And then also, this is where the issue of whether the private company has the right to take, if there's a question about that, about whether they're actually using it for a public use, that gets litigated at the trial court level. That's going to be a fight where both sides will make motions, ask discovery, do a bunch of stuff about that, and dive into it. And that would be that would be an issue there. So so an appeal to the trial, your case is not over after a special commissioner's hearing. You move on to the trial court. That doesn't necessarily mean you're going to make it all the way to a jury trial, but it is the next step in the process. And I think something that throughout the steps in the condemnation process, something that I always think is important for landowners to know is that the negotiations are always ongoing. They don't stop. And they can happen at any time. There's rarely a point where a condemning authority just says, no, I'm out. I'm not gonna negotiate with you anymore. Ultimately they're trying to get the piece of property for the price that's right in their mind, and then start their project. So throughout the process, there's generally always room for negotiation, no matter where you are.
Thanks, Carly. Carly, we're going to start wrapping up now. And this is a recent example. Mark Hefner, why don't you set this one up?
Yes, thanks, Patrick. So as the landowner advisor, I get calls from concerned, often distressed individuals. In this case, this landowner's wife, as you can see, are going to be dramatically impacted by a gas pipeline. They called and wanted to know what could happen. What can we do? They had received an offer from the company and had some discussion. And like I mentioned, very distressed. And so my role was to give them just some basics, determine what they wanted to do or what they potentially could do. And I made an introduction. And lo and behold, it was to you and your team. And so, Patrick, I'll let you kind of take the as far as what details you want to share from there. But it sounds like we've got at least a working relationship with the individuals now.
Yeah, thanks, Mark. And when they called, Mark had educated them very well about many of the land use items. So they called and said, what can we do? And the red line is the Atlas route that Atlas chose. There's no routing process. They can just draw a line on the map and put it anywhere they want to. The line that is basically a mirror image with the X on it, that was the initial proposal, and it was going to go primarily on the neighbor to the south. Well, the neighbor to the south was able to negotiate, and we don't know the terms, an effort to push it off of their property onto our client's property to the north. That is a 30-inch gas line. It's not paralleling any existing line, so it's a brand new line. This home is valued at over $1 million. It's going to be within 1,000 feet of their home, which there's a lot of technical issues related to a high pressure gas line being so close to a home. They can't tie into it. This is not for residential use. This is a transmission of gas. The offer was $50,000. They just got their appraisal. It was $26,000. So that's a methodology that they're using. We're in the process of hiring an appraiser, but given that slide that we showed you, you can imagine our appraisal is going to come in the hundreds of thousands of dollars. So we're gearing up for the fight on this one because that's what's going to be required to get what we believe is constitutional adequate compensation.
Excellent, excellent. You and Carly both did a great job of kind of letting let them know where an attorney can help. In summary, if I'm listening and all the various stages, can you briefly, and I know we're running a little short on time, but can you kind of give us a brief overview? If I called, why would I need an attorney? Where would I plug you guys in? And can it be in various stages? Like I think what you just alluded to with this family is you're plugging in, even though you would have preferred to be in earlier, it sounds like you can also plug in at various stages. Can you give us just a quick overview of how that would look and where you would plug in?
Yes, we can be retained at any point in time. I prefer to get in early, but I just got hired on a project in Reeves County in the Pecos, Midland, Odessa area. He went through the commissioner's hearing by himself, did not get what he considered adequate compensation. It's at the trial level. We just got hired. Where attorneys can really help is evaluate the case. And Carly can explain this. But when we look at a case, sometimes the offer is sufficient. If LCRA is offering a 35% signing bonus, and we look at it and go, you know what, I don't think we can help, we will tell you. Or we look at it just like in the last slide, absolutely, I guarantee you we can help. We know the process. It's a very complicated legal process. We understand that process. We understand landowners' concerns. We have a lot of ideas that a landowner may not think about, but you know, I always learn something from my clients. The landowners always teach me something else. It is a complicated process. I have an appraisal is not like a bank appraisal or a loan appraisal when it comes to condemnation. There's only a few appraisers out there in the state of Texas who do this. They have to be able to understand these very complicated issues, as well as potentially other experts. So we can help guide the landowner on what we believe is fair, what are the potential outcomes, and what is the cost going to be to the landowner in order to achieve a greater result. Carly, you have something to add?
Yeah, I think, appraising is certainly an art, not a science. So, and I think that that's a big part of what an attorney can do is to help you with your experts and appraisers and get you connected with the right people who are gonna get you the most amount of just compensation, who are gonna get you all the information you need to present the best case against the condemning authority, against the oil and gas company, things like that. So while Patrick said we like to get in at the very beginning because sometimes you can get lucky and maybe reroute that pipeline onto your neighbor's land. And certainly we can always step in and help on a case. So.
The other part about that is, for example, I have a client south of College Station, Bryan. I've been working with them for 3 years on this project. They just now got their initial offer, and they're elderly, and they just feel so much more comfortable because the condemning authority and those representatives do not have the landowner's best interests. And frankly, there's a lot of misrepresentations that are given to landowners that we can say, nope, that's not the case. Don't worry about that. Don't feel panicked. We have time. We'll get through this. So as attorneys and counselors, the counselor part of that really comes into play because condemning authority agents just want to get the ink. They want to get the project done. They want to just get it signed up and over with and get you paid and move on. Where we come in is for you to help understand the process. And there is always the time to resolve the case. In Texas, we say pigs get fat and hogs get slaughtered. We want to know where that tipping point is so that you can get the best deal that you can, without hiring an attorney and getting less. We would never take on a case if we didn't feel like we could value add services and get you more through the process.
Thank you, guys. So real quick, we'll talk about closing this down and how to get a hold of everyone. If you're interested in staying abreast of changes, updates, whatever it is, the Landowner Alert System is a fantastic resource. So please subscribe to that. There's a link down there. And then Carly, if you want to go to the last page, as we discussed earlier, you have direct contact to both Patrick and Carly and myself. They are the attorneys and counselors. If you want to go directly to them, send them an email, call that phone number, speak with him. Awesome. Please feel free to do that. They welcome your call and love to speak to you. If you would prefer to not speak to attorney right away and just want to give me some ideas or thoughts, then please feel free to call me or email me. Happy to do that as well. I do meet quite a few folks that seem to be a little more comfortable coming to me first. We chat, we talk, and then I make a warm introduction to the folks that can really help you out. So please feel free to reach out to us. Don't hesitate to ask questions and connect with us. Carly or Patrick, do y'all have anything else before we close this up?
Thanks for joining us.
Well, we do provide a consultation. Traditionally, we give a 30-minute free consultation. Sometimes it takes longer. Don't tell my partners I said that. Oh, this is being recorded. They're going to know. But, Carly just recently looked at an appraisal on a project and told the landowner that it's a good deal. There's really nothing we can add. And we didn't charge for that service.
That's great. I think that's very important to mention that you guys are there to really be that attorney and counselor and help them. And it's not just about seeing how much you can milk out of anyone. Y'all have a fantastic practice. Appreciate that. All right. So thank you for the reminder on the 30-minute free consultation. That's always a good thing to mention. And thank everyone for their attendance. And we appreciate you being here and sticking with us. So thank y'all again.
Do we have any questions before we sign off, either through the chat or audible questions if you want to go off mute, or send us an email if you'd like to have the private consultation?
Perfect. Thank you, Patrick.
Thanks.